Okay, good afternoon. Let us discuss limited partnership. Okay, now under Article 1843 of the Civil Code, a limited partnership is one formed by two or more persons under the provision of the following article, having as members one or more general partners and one or more limited partners. The limited partners as such shall not be bound by the obligations of the partnership. Now, based on 1843, okay, you cannot form a limited partnership wherein all partners are general. And you cannot also form a limited partnership wherein all partners are limited. Because the law requires that there must be at least one general partner and at least one limited partner. Kaya hindi siya pwedeng puro. Okay, kailangan combination siya ng general and limited. Kasi just imagine kung lahat ng partners are general, bakit ka pa nag-form ng limited partnership? But you cannot form a limited partnership wherein all partners are limited. Kasi there must be at least one general partner to answer for partnership obligation in order to protect an innocent third person. Kasi just imagine if all members of a limited partnership are limited, okay, sinong magbabayad after exhausting all partnership assets? Kaya walang protection ang innocent third person. Kaya the law requires that there must be at least one general partner. Okay, and you will also notice that a limited partner is liable only to the extent of his capital contribution. Okay, meaning, pag na-exhaust na yung entire partnership asset, okay, yung limited partner, hindi yan liable sa third person. Kaya lumalabas, isa lang ang exempted sa liability. Okay, sa third person. Only a pure limited partners. Unlike yung industrial partner, which is general partner din siya, exempted siya from losses, pero hindi siya exempted from liability. Now, take note that, okay, in order to form a valid limited partnership, there are two requirements. First, okay, dapat merong sworn statement na naka-indicate substantially all the requirements set forth by law. Okay, and second, kailangan siyang i-file before the Securities and Exchange Commission. Okay, pero ang question mo is, sir, what if hindi na-comply yung dalawang requirements set forth by law? Is there a valid partnership? The answer is yes, but only a general partnership is formed. And therefore, all members, okay, in this case, are considered general partners, and therefore they are liable to the extent of their separate property. Okay, kasi yung requirement under the law, okay, na sworn statement na naka-indicate substantially all the requirements set forth by law at yung filing before the SEC, okay, is only requirement to form a valid limited partnership. But it does not mean na walang partnership. Kasi makikreate pa rin yung tinatawag na general partnership. Yun nga lang, lahat ng members are liable to the extent of separate property. Pero take note, if there is a partner who contribute an immovable property, there must be an inventory of the real properties signed by the partners and attached to the public instrument. Kasi failure to comply that requirement would render the contract of partnership null and void. Okay, yan yung Article 1771 in relation to Article 1773. Okay? Now, general rule under 1843. The limited partners as such shall not be bound by obligation of the partnership, di ba? Okay? Kaya siya lang talaga yung exempted. Pero take note, merong exception. wherein a limited partner is liable to the extent of their separate property. Number one, the name of the partnership failed to add the word limited or LTD. Kasi isang requirement doon sa sworn statement, sa paragraph 1, dapat yung partnership name, meron siyang extension word na limited or LTD. Kasi pag ang partnership name, walang LTD or limited, only a general partnership is formed. Okay? That's why all members are liable to the extent of their separate property. Kasi walang substantial compliance. Second, hindi nyo final yung article of co-limited partnership before the Security and Exchange Commission. Kaya lumalabas ang na-form lang general partnership. That's why all members are liable to the extent of their separate property. Okay, even though by agreement you are a limited partner. Next, okay, the contribution of a limited partner may be cash or property but not services. In other words, if a limited partner contribute industry, automatic he become liable as a general partner. Kaya liable na siya to the extent of their separate property. Another, yung surname ng limited partner na include sa partnership name. Bawal kasi yun eh. Kasi once na-include ang name ng limited partner in the partnership name, then this limited partner becomes liable as a general partner. Pero by the way, meron siyang exception. Number one, okay, it is also the surname of a general partner. Kasi baka mamaya, kapangalan lang pala ng limited partner yung general partner. Kaya kahit na-include yung surname niya sa partnership name, hindi siya liable to the extent ng separate property. And second, prior to the time when the limited partners became such, the business now has been carried on under a name in which his surname appeared. Kaya halimbawa, bago siya ma-admit as member ng partnership, yung kanyang surname, ginagamit na nung partnership. In that case, hindi siya liable to the extent of their separate property. And another is a limited partner takes part in the control of the business. Kasi tandaan nyo, ang limited partner, they are not allowed to participate in the management. Kasi once nag-take part sila sa management, then this limited partner becomes liable as a general partner. Now, what are the distinction between a general partner and a limited partner? Number one, a general partner is personally liable for the partnership obligation. Kasi ang general partner, liable yan to the extent of their separate property. Okay, unlike ang limited partner, they are liable only to the extent of their capital contribution. Second, okay, sa general partner, when a management now has not been agreed upon, all general partner have equal right in the management of the partnership. Kasi di ba pag walang appointed manager, all partners are considered as managing partner. That's why all of them, as a rule, can perform all act of administration, but not strict dominion. But a limited partner cannot participate in the management. Kasi once a limited partner participate in the management, then he become liable as a general partner. Next, a general partner may contribute money, property, or industry to a common fund. While a limited partner may contribute money or property, but not industry. Next, general partner is a proper party to proceeding by or against a partnership. Okay? Kasi di ba ang general partner kasi, being an agent of the partnership, he can represent the partnership as well as the other partners. Kaya proper party siya in a proceeding by or against the partnership. While a limited partner is not a proper party to proceeding by or against the partnership. Okay, next, a general partner may appear in the firm name. Pero pag limited partner, okay, prohibited. Kasi once the surname of a limited partner is included in the partnership name, then he become liable as a general partner. Next, a general partner cannot engage in a business which is of kind of business in which the partners engage in. By the way, okay, whether capitalist or limited partner, meron silang common denominator. They are prohibited to engage in the same kind of business in which the partnership is engaged in. Yun nga lang pag industrial partner, 'di ba? Yun nga lang okay, talagang totally prohibited siya. Whether similar or not similar to the business ng partnership. Unlike doon sa limited partner, there is no prohibition. Kasi ang reason dito is that ang limited partner kasi purely capital lang. Okay? They are not allowed to participate in the management. That's why there is no prohibition. Now, what are the distinction between a general partnership and a limited partnership? Number one, sa general partnership kasi, in case of disease, death, insanity, civil interdiction, insolvency, saka retirement, okay, magkokos siya ng dissolution. Pero by the way, wala akong binanggit na automatic. Kasi, okay, kasama yung insanity. Because insanity is not a ground for automatic dissolution. While in a limited partnership, sabi dyan, do not the same effect. Executor or administrator shall have all the right of a limited partner for the purpose of setting his estate. Ganito kasi yan. Sa limited partnership kasi, if a limited partner die, hindi siya magkakos ng dissolution. Kasi yung, okay, if a limited partner die, automatic his executor, administrator, become a substituted limited partner. Okay, now question. Kailan nagkakaroon ng tinatawag na substituted limited partner? Actually, there are only 3 instances wherein magkakaroon ng substituted limited partner. Number 1, okay, if all partners agree for the substitution. Second, yung right for substitution is indicated in the certificate. Ibig sabihin, nakalagay doon sa article of co-limited partnership, okay, na yung right for substitution. And last, when a limited partner die. Kasi when a limited partner die, automatic his executor, administrator become a substituted limited partner. Okay? Now, question uli. Halimbawa, si A is a limited partner. Ang ginawa niya, transfer niya yung interest kay X. Ang question, is X now become a substituted limited partner? The answer is no. Assignee, limited partner lang siya. Kasi magiging substituted limited partner lang si X kung, number 1, nag-agree nga lahat ng partners no sa substitution. Or second, yung right for substitution, naka-indicate sa certificate. Eh kung wala naman nakalagay sa certificate, hindi siya substituted limited partner. And number 3, when a limited partner die nga. Okay? Kaya ang tawag lang sa kanya, assignee limited partner lang. Now, ano bang distinction ng okay, substituted limited partner doon sa assignee limited partner? Kasi pag sinabing substituted limited partner, lahat ng right ng limited partner na-acquire mo. Okay, and what are the right of a limited partner? Actually, same as a general partner except they are not allowed to participate in the management. Entitled ba ang limited partner to inspect partnership book? Yes. Are they entitled to demand true and full information regarding partnership affairs? Yes. Entitled ba silang mag-share sa profit, okay, by way of distribution of profit by way of income? Yes. Entitled din sila for the return of capital. Okay. Pero they are not allowed to participate in the management. Unlike pag-assign ni limited partner, kung ano lang ang right no, okay, right lang sa share sa profit, okay, na dapat ma-receive ng limited partner. Next distinction, sa general partnership, it may be constituted in whatever form. Pwede siyang oral, pwedeng writing. Okay? Ang writing, pwedeng private, pwedeng public instrument. except only pag nag-fall ng Article 1770. Okay? 2. Okay? Sorry, in Article 1771 in relation to 1773. Now, whenever there is contribution ng immovable property, there must be an inventory of the real property signed by the partners and attached to the public instrument. Kasi failure to comply those requirements would render the contract of partnership void. Sa limited partnership, okay, must follow all the requirement of law for limited partnership. Kasi dapat i-comply nyo yung dalawang requirement, di ba? Sabi ko, first, kailangan may sworn statement na naka-indicate substantially all the requirements set forth by law. And second, kailangan siyang i-file before the Securities and Exchange Commission. Kasi pag hindi mo na-comply yung dalawang requirements set forth by law, only a general partnership is formed. Next, sa general partnership, bali compose siya ng all general partner. Okay, limited partnership, composed ng at least one general and at least one limited partner. Next, sa general partnership, okay, hindi kayo required na i-indicate sa partnership name yung word LTD. Unlike in case of a limited partnership, okay, mandatory, the partnership name, dapat meron siyang extension word na LTD or limited. Otherwise, there is no valid limited partnership. Only a general partnership is formed. And last distinction sa general partnership, sabi dyan, when the interest of one of the general partner is charged, his interest may be redeemed with separate property of one or more partners or partnership property with the consent of all partners whose interest is not so charged or sold. Sa madaling salita, pag sa general partnership, pag ang interest ng general partner ay chinarge ng third person, dalawang pwede nyong gamitin. Number one, pwedeng separate property ng other partner. And number two, pwedeng partnership property, pero yun nga lang, kailangan ng consent ng all partners whose interest is not so charged. But in a limited partnership, okay, if the interest of a limited partner is charged by a third person, okay, isa lang ang pwede nyong gamitin. Only the separate property of a general partner. At hindi nyo pwedeng gamitin ang partnership property kahit may consent pa siya ng all partners whose interest is not so charged. Kaya pag binasa mo yung 1862, ang sinasabi dyan, when the interest of a limited partner is charged, the interest may be redeemed with separate property of any general partner. Pero hindi nyo pwedeng gamitin ang partnership property para i-redeem ang interest, okay, ng limited partner. Okay? Now, let us now proceed sa dalawang requirements set forth by law to form a valid limited partnership. Sabi ko, ang first requirement, kailangan nyo ng sworn statement. Okay, yung article of co-limited partnership na naka-indicate substantially all the requirements set forth by law. Marami yan hanggang end. Okay, and second, kailangan nyo siyang i-file before the Securities and Exchange Commission. Sabi ko nga, pag hindi mo na-comply yung dalawang requirement dito, meron pa ring valid partnership, but only a general partnership is formed. That's why all partners in this case are liable to the extent of their separate property. Okay? Ngayon, ano ba yung first item sa sworn statement? Dapat yung may name syempre ng partnership at dapat yung extension niya na word ay limited or LTD. Kasi pag walang word na LTD or limited, walang substantial compliance, only general partnership is formed. Okay, lagay niyo yung character daw ng business, location of the principal place of business, the name and place of residence of each member, general and limited, partners being respectively designated. Indicate doon lahat ng general, saka lahat ng limited. Okay, naka-indicate yung kanilang place of residence. The term for which the partnership is to exist. Kaya dapat meron siyang term. Hindi siya pwedeng partnership at will. Next, the amount of cash and description of and the agreed value of other property contributed by each limited partner. Kaya take note pag ang ginawa nyo dito ay inaggregate nyo yung total contribution of all limited partner. Walang substantial compliance. Kasi lawan, nilagay nyo sa article of co-limited partnership that total capital contribution of all limited partners amounting to 500,000. Hindi nyo siya sineparate, okay? Hindi nyo indicate yung contribution ng each limited partner kasi nilagay nyo is aggregate. Walang substantial compliance. That's why only a general partnership is found. Okay, another is the time if agreed upon when the contribution of each limited partner is to be returned. Okay, wait, nakalimutan ko. Okay, itong number, letter G. The additional contribution, if any daw, to be made by each limited partner and the times at which or event, okay, on the happening of which they shall be made. Kasi pwede kayo maglagay ng provision doon sa article of co-limited partnership, okay, regarding additional capital contribution of limited partner. Baka nakalagay doon, limited partner A will give additional capital contribution of 50,000 pesos on December 1, 2020. Kaya pag dumating or nag-arrive yung period na yun, then limited partner A is liable to the partnership. Kasi merong provision sa article of co-limited partnership regarding additional capital contribution. Another is the time if agreed upon when the contribution of each limited partner is to be returned. Kaya pwede nyo ilagay doon sa article, kailan ba i-return yung re-return yung capital ng limited partner. Nakalagay doon, the capital contribution of limited partner A will be returned on December 1, 2020. Kaya pag dumating yung December 1, 2020, limited partner A may now demand for the return of his capital contribution. Provided, mas malaki yung asset ng partnership kaysa sa partnership obligation. Kasi kung mas malaki yung partnership liability kaysa sa partnership, mas malaki yung partnership liability kasi sa personal, okay, partnership asset, that is a prohibited transaction. Another is the share of the profit or the other compensation by way of income which each limited partner shall receive by reason of his contributions. The right, if given, of a limited partner to substitute an assignee as contributor in his place and the terms and conditions of the substitution. Ito yung sinasabi ko sa inyo. Magkakaroon dito ng tinatawag na substituted limited partner because the right for substitution is indicated in the certificate. The right, if given, of the partners to admit additional limited partners. Okay? Now, may napansin ba kayo? Nakalagay dyan na the right, if given, of a partners to admit additional limited partners. Tapos dito naman, okay, walang nakalagay dito regarding, okay, additional general partners. Explain ko yan later sa inyo. Letter L, the right, if given, of one or more limited partner to priority over limited partners as to contribution or as to compensation by way of income and the nature of such priority. Kaya pwede kayo maglagay ng provision doon sa article of co-limited partnership na unang babayaran si limited partner A, pangalawa si limited partner B, then limited partner C. Pero pag walang naka-indicate regarding priority doon sa distribution, then the rule is that equal rights lang sila. Okay? Paragraph M, the right if given of the remaining general partner or partners to continue the business on the death, retirement, civil interdiction, insanity, or insolvency of a general partner. Okay? Now next, the right if given of a limited partner to demand and receive property other than cash in return for his contribution. Okay? Kaya pwede nyo lagay dito na ang ibabalik sa kay limited partner A, yung kanyang mismong actual, okay, property contributed. Pero pag walang naka-indicate, okay, doon sa article, then entitled lang siya for payment in cash. Okay, and of course, the second requirement is i-file nga siya, okay, sa SEC. Ngayon, gusto kong i-familiarize nyo to, yung 1850. Okay, ang general rule kasi, di ba? Pag general partner, okay, a general partner, okay, are allowed to participate in the management. Kaya yung limited partner, they are not allowed to participate in the management. Kasi once nag-participate sila, automatic they become liable as a general partner. Pero may nakalagay na provision sa Article 1850 na hindi pwedeng mag-act yung general partners alone without the consent of all limited partners. In other words, pag kinompare natin tong limited partner sa corporation setup, para silang non-voting shares. In fact, kung nare-recall nyo sa corporation law, okay, only those classified as preferred or redeemable shares may be denied of voting rights. And take note that even they are classified as non-voting preferred or non-voting redeemable shares, they are still entitled to vote in 8 instances. Okay, yan yung tinatawag na fundamental changes dun sa corporation. Tulad ng amendment ng Article of Incorporation, adoption and amendment ng corporate bylaws, sale, lease, exchange, pledge, mortgage ng all or substantially all ng corporate property, increase, decrease capital stock, incurring, creating, or increasing banded indebtedness, investment ng corporate fund other than for primary purpose, merger or consolidation sa corporate dissolution. Kaya kahit na mga non-voting preferred or non-voting redeemable shares yan, makakaboto pa rin sila doon sa 8 instances. Now, dito sa law on partnership, kahit na limited partner sila, and therefore they are not entitled to participate in the management, kailangan ang consent nila. Okay, or ratification dito. Kaya hindi pwedeng mag-act yung general partners alone without the consent of all limited partners. Okay? Pito rin yan. Pito lang to. Number 1, do any act in contravention of the certificate. Kaya kung gagawa ng act ang general partners na magko-contravene sa certificate, kailangan ng consent ng all limited partners or ratification. Okay, for second, do any act which would make it impossible daw to carry on the ordinary business of the partnership. Confess a judgment. Kung nare-recall nyo yung sa GAR CCA, di ba? Confession of judgment, impossible to. Okay, then possess partnership property or assign the right in a specific partnership property for other than a partnership purpose. Admit a person as a general partner. Admit a person as a limited partner unless the right so to do is given in the certificate. Okay, pa-explain ko sa inyo ito. May napansin ka ba? Pag magdadagdag ng additional general partner, kailangan may consent ng all partners, both general and limited. Pero pag magdadagdag ng additional limited partner, general rule, kailangan pa rin ng consent ng limited partners. Pero may exception unless the right so to do is given in the certificate. Kaya ibig sabihin, pwedeng ilagay sa certificate. Okay, balikan natin yung certificate. Ito yun, paragraph K. The right is given of the partners to admit additional limited partners. Okay? Kaya lumalabas, okay, may exception pagdating sa limited partner. Kahit walang consent ng all limited partners, pwede kung nakalagay sa certificate. Unlike doon sa admission of additional general partners, okay, mandatory. Kailangan may consent ng both general and limited. Wala siyang exception. Another is continue the business with partnership property on the death, retirement, insanity, civil interdiction, or insolvency of a general partner unless the right so to do is given in the certificate. Example lang. Halimbawa, ang partnership natin is A, B, C, D, E, wherein A, B, okay, A, B, C are general partners. Okay, and D, E are limited. Ngayon, ang problema, si A, for instance, namatay. Okay, anong effect? Dapat dissolve siya. General partner yung namatay. Okay? Now, ang question is that, pwede bang i-continue ng remaining general partner to? Yung operation, even without the consent of all limited partners? The answer is no. The rule is that kailangan may consent ng all limited partners. Pero pwede siyang ilagay sa certificate. Kasi nakalagay dyan, unless the right so to do is given in the certificate. O balik ka doon sa certificate, naka-indicate yan sa paragraph M. The right is given of the remaining general partner or partners to continue the business on the death, retirement, semi-interdiction, insanity, or insolvency of a general partner. Okay, kaya pakifamiliarize ha, itong 1 to 7, hindi pwedeng mag-act ang general partner without the consent of all limited partners or ratification of all limited partners. Ngayon, ano ba ang right ng limited partner? Sabi ko, same as a general partner. Una, pwede silang demand na yung book i-kept sa principal place of business ng partnership. And at reasonable hour, pwede sila mag-inspect and copy ng partnership book. Second, pwede sila mag-demand ng true and full information ng partnership affairs. Then, pwede silang mag-file ng petition for dissolution and winding up by decree of court. Okay, right to share sa profit and the right to demand return of capital. Pero wala silang right na mag-participate sa management. At sabi ko nga, kung kayo ay magiging substituted limited partner, ma-acquire mo lahat yung right dito. Kasi yung substituted limited partner, papaltan lang niya whatever be the right of a limited partner. Now next, contributor who erroneously believe he become a limited partner. Halimbawa si A, B, C, D, E, nag-form ng limited partnership. Ang agreement is A, B, C are general and D, E are limited. Pero ang problema, dun sa certificate, ang nakalagay kay D ay general. In that case, D is liable to the extent ng separate property. Kasi masusunod yung certificate. Pero may exception. That on ascertaining the mistake, he promptly renounces his interest daw. Okay, in the profit of the business or other compensation by way of income. And second, even if no renunciation daw, the partnership creditors are not prejudiced. Yan yung dalawang exception. Now, can a limited partner be a general and limited partner the same partnership at the same time? Pwede na bang maging general limited ka? The answer is yes. Pero siyempre may tanong ka. Possible ba yun, sir, na general ka, the same time limited ka? Eh, di ba ang general partner, liable yan to the extent ng separate property? Pero pag limited partner ka, liable ka lang to the extent ng capital contribution. Paano ka magiging general limited? Ang ibig sabihin lang nun, pag sinabing general limited ka, general liability ka sa third person, pero limited liability ka as among the partners. Kaya pag binasa mo yung Article 1853, sabi diyan, a person who is a general and also at the same time a limited partner shall have all the right and power and be subject to all the restriction of a general partner. Except that, in respect to his contribution, he shall have the right against the other members, which he would have had if he were not also a general partner. Now, question, can a limited partner transact business with a partnership? The answer, of course, is yes. Wag lang siyang prohibited transaction. Okay? That's why a limited partner may loan money to the partnership. Pwede siya mag-transact ng other business with the partnership to receive an account of resulting claims against the partnership with a general creditor a pro rata share of the asset. Okay? Provided pure limited partnership. Okay, ito ay prohibited transaction. Okay? Bawal ditong ang limited partner. Number 1, to receive or hold as collateral security any partnership property. Kaya ba limited partner si A, nakatanggap siya ng partnership property as collateral security. Bawal yun. Or pangalawa, halimbawa, si limited partner A, nakalagay sa certificate, entitled siya for return of capital due today. Okay? Pwede ba siya mag-demand ng return of capital today? Yes. Pero ang problema, today, yung asset ng partnership kulang pambayad ng outside obligation. Kaya bawal i-return ang capital ni A. That is a prohibited transaction. Okay, may tanong, kasi paano kung binalik pa rin? Okay, yung capital ni limited partner A today, even though mas malaki yung partnership liability kaysa sa partnership asset, in that case, hinohold lang ni limited partner A yung proceed as a mere trustee for the benefit ng partnership creditor. At pag na-discovered ng partnership creditor, pwede silang mag-file ng action for rescission. Okay, sapagkat yan ay rescissible kasi pwede siyang i-treat as fraudulent transaction. Now, what are the conditions for the return of contribution? Okay, ano raw yung requirement para mabalik yung capital contribution ni limited partner? Siyempre, una, dapat mas malaki yung asset ng partnership kaysa sa partnership obligation. Pangalawa, dapat nag-consent daw lahat ng members dun sa return of capital. Okay, ang exception lang unless, di ba, sabi dyan, yung right for return of capital naka-state sa certificate. Kasi pwedeng ilagay doon sa article of co-limited partnership kung kailan ibabalik yung capital contribution ng limited partner. And last, dapat yung certificate daw, which is the article of co-limited partnership, either i-cancelled mo siya, okay, or i-amend. Sabi mo, sir, kailan kayo magka-cancelled? Kailan tayo mag-a-amend? Tandaan nyo na lang yung cancellation. Kasi pag hindi ka magka-cancel, malamang mag-a-amend ka. Kasi basta't meron kayo, may binago kayo or any changes doon sa article of co-limited partnership, you need to amend. Now, kailan ba kayo magkakaroon ng cancellation ng limited, cancellation ng article of co-limited partnership? Okay, dalawang instances lang. Una, upon dissolution. Kapag dissolved na yung limited partnership. And second, when all limited partners cease to be such. Sabi sa ibig sabihin nun, example lang. Halimbawa, merong 5 partners. A, B, C, D, E are limited. A, B, C, D, E are partners of limited partnership. Okay, wherein A, B, C are general and D, E are limited. Later on, si E nag-withdraw. In that case, cancellation siya or amendment? Answer, amendment lang. Bakit? Kasi may natitira pang isang limited partner, kaya meron pa ring limited partnership. That's why you need to amend lang. Pero halimbawa, let us modify. There are 5 partners, A, B, C, D, E, wherein A, B, C, D are general partners and E is the limited partner. Ang problema, si E later on nag-withdraw. In that case, kailangan yung i-cancel ang certificate. Why? Bakit siya cancellation? Because there is no more limited partner. Kaya wala na rin valid limited partnership. Kasi dapat, di ba, may at least one general partner and at least one limited partner. Okay, kaya since nag-iisa na lang siya, nag-withdraw pa siya, di wala nang valid limited partnership. Kaya tandaan nyo, dalawa ang grounds for cancellation. Number 1, upon dissolution, and second, when all limited partner cease to be such. Meaning, walang natira na limited partner. Basta't ang ating rule of thumb dito, okay, dalawa lang ang grounds for cancellation. The rest, puros amendment siya. Pero syempre, may possible din na wala kang gagawing amendment kung wala ka namang binago sa certificate. Next, time when contribution of limited partner can be returned. No? Kailan daw pwedeng ibalik ang capital contribution of a limited partner? Syempre, number 1, upon dissolution. Second, when the date is specified to certificate for its return as a right. Ibig dumating na yung period na naka-indicate sa certificate for return of capital. And 3, after he has 6 months notice in writing to all other members, if no time is specified in the certificate, either for the return of the contribution or for the dissolution of the partnership. Okay, now, share of profit or compensation by way of income. Entitled ba ang limited partner dito? Of course, the answer is yes. Provided yung partnership asset daw is more than all liabilities of the partnership. Except liabilities to limited partner on account of their contributions and to general partners. Now, next, when a limited partner liable to the partnership. Kailan daw magiging liable ang limited partner sa partnership? Number 1, for the difference between his contribution actually made and that is stated in the certificate as having been made. Kasi halimbawa, nakalagay sa article of co-limited partnership, ang contribution ni limited partner A is 500,000. Pero yung palang kanyang actual contribution, 300 pa lang. Kaya merong difference yung naka-state sa certificate saka yung actual contribution na 300. Kaya liable si limited partner A sa partnership for 200,000. Number 2, for any unpaid contribution which he agreed in the certificate to make in the future at the time and on the conditions stated in the certificate. Halimbawa, nakalagay sa certificate, limited partner A will give additional capital contribution of 300,000 on December 1, 2020. Kaya pag nag-arrive yung December 1, 2020, then limited partner A is now liable to the partnership. Okay, next, when a limited partner liable as trustee for the partnership. Bali, number 1, is specific property is stated in the certificate as contributed by him, but which was not contributed or which has been wrongfully returned. Okay, example. Naka-indicate sa certificate that limited partner A contributed a Toyota Altis 2016 model with plate number XYZ123. Pero yun pala, hindi pa dinideliver or kino-contribute ni limited partner A to sa partnership. Now, in that case, okay, hinohold lang niya yung car as a mere trustee for the benefit of the partnership. Next, money or other property wrongfully paid or conveyed to him on account of his contribution. Kasi halimbawa, binalik yung capital contribution ni limited partner A, pero ang problema, mas malaki pala yung liability ng partnership kesa doon sa partnership asset. Eh di ba sabi ko that is prohibited transaction. Kaya wrongfully returned yun. Okay, paid or conveyed to him. In that case, hinohold lang niya yung return of capital as a mere trustee for the benefit of the partnership. Now, kailan nga nagkakaroon ng substituted limited partner? Okay, sabi ko tatlo lang ang instances. Number 1, lahat ng members nag-consent sa assignment. Number 2, if the assigner being under to empowered by the certificate gives the assignee that right. Ibig sabihin, yung right for substitution naka-indicate sa certificate. And last, pag namatay, of course, ang limited partner. Kasi sabi ko nga, pag namatay ang limited partner, automatic yung kanyang executive administrator become a substituted limited partner. Automatic siya. Now, when certificate must be cancelled? Kailan nga ika-cancel ang certificate? Binanggit ko na kanina yan. May dalawang instances lang para ma-cancel ang certificate. Number 1, when the partnership is dissolved. And number 2, when a limited partner ceases to be such. Pero by the way, class, may ka-clarify lang ako sa inyo dito. Okay, doon sa okay, when the partnership is dissolved. Kasi halimbawa, okay, namatay for instance yung general partner. Technically dissolved siya. Okay, pero ang problema, i-continue pa rin nung existing general partner yung partnership operation. Ibig sabihin, may limited partnership pa din. Kaya, kailangan nyo pa rin ang certificate. Kaya hindi mo siya i-cancel. I-amend mo lang. Sa madaling salita, as long as meron pa rin limited partnership, you need to amend lang. Pero kung nag-decide for instance na namatay yung limited partner na i-liquidate, i-wind up na lang ang partnership affairs. In that case, okay, kailangan nyo nang i-cancel ang certificate. Kasi kung i-liquidate nyo na siya, i-wind up na yung partnership affair, there is no need for the certificate. Kasi wala nang valid limited partnership. And of course, number 2, when all limited partner cease to be such. O ibig sabihin nga, walang natira na limited partner. Tulad yung kaninang illustration ko, kung meron lang 5 partners, wherein A, B, C, D are all general, and E is limited. If later on E retire or withdraw, in that case, you need to cancel the certificate because there is no more limited partnership. Next, when a certificate shall be amended. Now, kailan kayo mag-a-amend? Rule of thumb. Dami niyan eh. Basta't may binago ka sa certificate, i-amend mo. Okay? As long as meron pa ring existing limited partnership. Amend lang. Pero kung wala namang apektado dyan, do sa content ng article of co-limited partnership, edi wala ka rin gagawing amendment. Okay? Di ba? Yan. Una, nag-change of name ka. Okay? Change in the name of the partner. Then charge a change in the name. Di ba yun yung first item, binago mo, mag-amend ka. Nagkaroon ng substitution ng limited partner. O kaya nagkaroon ng additional limited partner. Nagkaroon ng additional general partner. Okay? Mag-amend ka syempre niya. Pero technically dito, general partner, dissolve. Pero since i-continue pa rin, then amend mo lang ang certificate. O kaya a general partner retires, dies, becomes insolvent or insane or is sentenced to civil interdiction and the business continued. Meaning tinuloy pa rin nung remaining general partner. Okay, there is a change in the character of business. Di ba yun yung second paragraph, character ng business ng limited partnership. Now, there is a false or erroneous statement in the certificate. Kung merong mali doon sa certificate, binago mo, mag-amend ka lang. There is a change in the time as stated in the certificate for the dissolution of the partnership or for the return of contribution. A time is fixed for the dissolution of the partnership or the return of contribution, no time having been specified in the certificate. And the members desire to make a change in any other statement in the certificate in order that it shall accurately represent the agreement among them. At ang rule of thumb dyan, basta may binago ka sa certificate, kailangan mo siyang i-amend. Okay? Ito, commonly asked question in the CPA board exam. Lagi siyang tinatanong. Ano ba yung pinagkaiba ng general partnership versus limited partnership with respect to distribution of assets? Okay, pansinin mo sa general partnership, ang unang binabayaran dito, outside creditor. Sumunod, inside creditor. Yung mga, utang doon sa partner. Tapos next, capital and last profit. Manonotice mo sa general partnership, unang binabayaran ng capital, last yung profit. Pero sa limited partnership, may manonotice kang dalawa. Una, first, ang unang binabayaran is, unang binabayaran ng limited partner than a general partner. Second, unang binabayaran, ang profit than capital. Kaya manonotice nyo, ang una nyong babayaran sa limited partnership, outside creditor. Tapos pangalawa, limited partner with respect to profit. Limited partner with respect to capital. Then, general partner other than for capital and profit. Then, general partner in respect to profit. And general partner with respect to capital. By the way, pag silent ang problem, the assumption is that is a mere general partnership. Kasi para makapag-form ka ng valid limited partnership, di ba sabi ko kailangan na comply lahat ng requirement set forth by law. Kasi pag hindi na comply lahat ng requirement set forth by law, it means there is no valid limited partnership. Kaya magkakaroon lang tayo ng tinatawag na general partnership. Okay, kaya tingnan niyo sa problem kung silent lang siya. It means general partnerships. Okay? Now, let us discuss. Okay, tapos na. Finish na.